Stop starving Gaza! Stop starving Gaza!
Free Palestine!
90,000 pro-Palestinian demonstrators crossing Sydney's Harbour Bridge.
The pro-Palestine protest was peaceful and orderly. The only problem, too many people turned out.
On 2nd August 2025, during heavy rain, over 90,000 people gathered on Sydney Harbour Bridge behind me for a large-scale protest to condemn the humanitarian crisis in Gaza. Simultaneously, thousands of people took to the streets in Melbourne and Adelaide showing their support and echoing with similar protests in London and New York.
An interesting fact is during the rally, the crowd and the police appeared to have reached an understanding. The police deployed a large number of officers to maintain order, but throughout the event, they remained calm and restrained. The protesters, on the other hand, remained orderly and did not engage in large-scale clashes or acts of violence with the police. From a legal perspective, why did the police tolerate such a situation? Why did the government give the green lights? How are various fractions engaged in a fierce power struggle behind the scenes? We are now to review the answers in this video. While people believe this was an unexpected incident, everything had already unfolded according to a predetermined script. On 1st August 2025, representatives of the rally and the police engaged in a heated courtroom debate at the Supreme Court of New South Wales. A final judgment was recorded in the case Commissioner of Police and Joshua Lee 2025 NSWSC 858. If you want to read the judgment and my highlighted notes, you may download it from the link in the comment section below. Before digesting the arguments and evidence in this case, let's first understand a few basic concepts. Firstly, the Australian Constitution protects the freedom of assembly. However, the Constitution is a guiding document and cannot specify every details of its implementation. Therefore, the relevant legislation in this case is the Summary Offences Act 1988. Summary offences are to be distinguished from the concept inductible offences. We are not going to elaborate those topics due to time limitation, but simply put, summary offences refer to less serious crimes typically punishable by up to 2 years in prison. Common examples include drink driving, which is processed through the summary procedure. Inductible offences generally refer to more serious crimes such as murder and robbery. Now, in this case, the relevant provisions are Section 23, 24, and 25 of the Summary Offences Act. In simple terms, Section 23 states that the public assembly is authorized if the notice of at least 7 days has been served to the Commissioner of Police and the notice meets certain criteria. Section 25 states that the police may apply to the court for prohibition orders. If no such application has been made or no such orders have been granted, the police may not prevent the public from exercising their right to assemble. Section 24 essentially states that if the assembly gives the police 7 days notice and the police does not obtain such prohibition orders, participants in the assembly are exempt from criminal prosecution. This is also known as Section 24 exemption. Now that we have clarified those concepts, let's examine how the two sides argue their cases. First of all, the police has called a few witnesses. That include number 1, Assistant Commissioner Adam Johnson, number 2, Chief Inspector in the New South Wales Police Force, Brian Yates, number 3, Acting Assistant Commissioner of Fire and Rescue New South Wales, Matthew Walmart. Lastly, Executive Director Operations Planning in the Coordinator General Branch of Transport for New South Wales, Grant Noitz. The main evidence and arguments presented by the police can be summarized in few points. Firstly, the notice period was too short to make any arrangements. Compared to previous New Year's Eve, Christmas, or other large-scale gatherings on the Sydney Harbour Bridge, which typically require several months of preparation in advance, this gathering was only given a 7-day short notice period, which was overly rushed. Although 7 days is the legally mandated minimum notice period, an event of this scale requires advanced planning and close coordination among various public service agencies, such as the police, transportation department, and fire and rescue. Without several weeks or even months of preparation, it would have been impossible to make adequate arrangements. Number 2, the police said the notice clearly stated 10,000 participants were estimated to join the assembly. But on social media, the organizer encouraged over 100,000 people to attend, which is an unprecedented scale. So the police point is that the notice was not very objective or accurate. At the end, over 90,000 people took to the streets, proving the police prediction was actually correct. Number 3, traffic closure poses safety risks. Moreover, the event has political sensitivity, so if violent incidents occur, such as someone fainting or needing emergency medical attention, how would ambulances access the area? If a fire breaks out, how would fire trucks get through, etc.? Of course, this turned out to be unnecessary worry as it poured rain that day, so there was no need to talk about fires, everyone could just pour water on the bridge. That's a side note. But looking at the 3 points raised by the police, they appear to be reasonable and well-founded. So how did the protesters respond? Well, the organizer of the gathering is an individual named Joshua Lee, who testified in court and provided 2 crucial pieces of evidence. Number 1, the organizer and his team have years of experience collaborating with police and maintain regular communication, so they have a so-called constructive relationship. A key detail is that the Joshua Lee stated he frequently used a mobile device during the protest to update the police on current situation, and marshals themselves spoke on walkie-talkies, enabling real-time communication, pretty much like play an online game. The police themselves acknowledged this was indeed the case. Second, the rally was completely controllable, with leaders from all levels providing unified command. So this was not an unorganized event, but one with a strict plan and leadership. It was detailed down to which head marshal or lower-ranked marshal was responsible for what. For example, when to move forward, when to deliver speeches, and when to turn. Moreover, every level of leadership obeyed the organization's instructions and had many years of experience in street protests. So how to prevent the situation from being out of control, how to coordinate distances and relationship with the police, these are all well-rehearsed procedures. So in real life, protests led by organizers have very low probability of resulting in violent or disturbing incidents. On the other hand, unorganized street marches are most likely to lead to vandalism, looting, and massive chaos, just like what happened in US back in 2020. The last point was summarized by Joshua Lee's lawyer. The law inherently grants applicants immunity from prosecution because demonstrators have provided 7 days' notice. That grants them Section 24 exemptions. Therefore, it is the police's responsibility to prove that the citizens cannot enjoy such immunity, not the other way around. So it's not the demonstrators' responsibility to prove that they may cause public disturbances. Finally, let's look at how the court ruled. Judge Rigg stated that the difficulties to be balanced were, on one hand, the public interest in freedom of speech, and on the other hand, the safety considerations required for a large-scale event with so many participants. After comprehensively reviewing the evidence and arguments presented, it is concluded that the evidence presented by the organizers were credible. Joshua Lee had a relatively good track record. The marches participated by him had very few criminal incidents, so therefore the court almost entirely accepted Joshua's evidence. This demonstrates that one's actions are observed, and any public records of past behavior can either assist or hinder one at critical juncture. Secondly, the judge cited 2 particularly striking statements in the judgment, which I will share with you here. The first is Justice Simpson in a case called Rinto. It is a 2003 case when he was asked to comment on whether assemblies would cause pressure on public facilities as a whole. He said this: public facilities are to be shared, and occasionally even a regular user has to give way to the claims of others. It is the very nature of the entitlement to peaceful protest that disruption will be caused to others. The fact that the proposed assembly is likely to cause significant inconvenience to residents of Pennant Hills and to individuals involved in the events at the park is far from determinative. If matters such as this were to be determinative, no assembly involving inconvenience to others would ever be permitted. Another quote is from Justice Adamson in Gray's case. He said, "The timing of the protest is also of significance. Ms. Gray's evidence is that the momentum gathered by the death of George Floyd has provided an opportunity for those who wish to effect social change in Australia to make their voice heard. To deprive such groups of the opportunity to demonstrate in an authorized public assembly would inevitably lead to resentment and alienation if the public risk concerns did not warrant it." The meaning of this message is that once a social event occurs, assemblies must be timely to reflect the constitutionally protected freedoms. If one wants to wait several months, the situation may be temporarily pacified, but in the long term, social conflicts will intensify. Just like water, when it is full, it overflows. Water can carry a boat, but it can also overturn it. The Supreme Court of New South Wales faced a balancing exercise between the freedom of assembly and public safety in this case. Its ruling allowed us to witness during a downpour a harmonious sympathy of goodwill and care for nature intertwined with order and restraint. If such a social gathering were to occur again and you were the judge, what decision would you make? Let me know your thoughts in the comments below. See you next time.